So I have an update in the suppressor freedom lawsuit, which aims to remove state bans on the purchase and possession of suppressors. So let's break down what just happened. Now, before we jump into this video, I want to thank the sponsor of this video, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR isn't a league of its own. AOR is a real law firm, so they will help you in self-defense incidents that maybe other companies would not. And AOR has added a lot of new benefits if you sign up this year, and it's no extra cost to you if you sign up. Those new perks include civil liability coverage up to $100,000, red flag law coverage up to $15,000, and then expungement coverage up to $5,000. So if you're interested, check them out using the link down below. And if you sign up and you use the code ARMEDSCHOLAR, you can get $50 off your individual sign-up plan or $25 off of the family plan. Now, as I mentioned in the intro, in this video, I have an important update for you in the lawsuit, which aims to remove a statewide ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Morse versus Raoul. This lawsuit can kind of be the first one in the nation which finds that states cannot outright ban NFA items like suppressors, and to do so would be unconstitutional. This decision here and this lawsuit could impact other states that outright ban NFA items like California, which restrict the access to suppressors and SBRs. Currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment. And as a result, the state of Illinois is currently requesting that the judge here grant a judgment on the pleadings and essentially throw the case out at this early stage. In this case, the state of Illinois asked the court to take notice of the Fifth Circuit's recent decision, which held that suppressors are not arms and that they are not 100% necessary for a firearm to function. Now, in this case, the plaintiffs argue that suppressors are not dangerous and unusual, and that the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes. The state of Illinois recently filed that motion for a judgment on the pleadings to try to get this case thrown out at the early stage. In their motion, Illinois argues that the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike at another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearms ownership that a firearm cannot be used effectively without them. Silencers are therefore not arms within the original meaning of the constitutional text. They also go on to argue that silencers are simply accessories, they're not a necessary accoutrement of a firearm, and therefore they can also be restricted. Now, of course, this contradicts the fact that under federal law, the NFA treats these items as actual firearms, but they want to, avoid that. They want to get around that and just completely ignore it, say, it doesn't matter what the federal level actually defines these items. We are simply going to say that they're accessories, and as accessories, they're not protected. Now, the hearing on the motion was temporarily stayed by the judge because he believed that the Illinois rifle decision and the consideration of the Illinois PICA law could impact what happens in this suppressor case. Now, the judge in the suppressor case wanted to see how that lower court applied the Seventh Circuit's recent decisions on rifle bans and, consider maybe how some of the PICA language dealing with flash suppressors and threaded barrels could impact this suppressor challenge. Recently, Judge McGlynn in that PICA case issued a decision striking down the entire law as unconstitutional, and because of that, the plaintiffs in this suppressor case have submitted that win as support for why their motion for judgment on the pleadings, should be denied, why that motion should be denied, and why the suppressor case should move forward, and ultimately the suppressor ban should be struck down. Now, in response, the state of Illinois has also submitted a supplemental notice, and that is in relation to the Fifth Circuit Peterson case. The Peterson case out of the Fifth Circuit involves an individual who had a gun store that was raided by the ATF. Now, during that raid, the ATF found a single solvent trap that was not registered or serialized, and because of that one item, the individual there, Mr. Peterson, was charged with violating the NFA. Mr. Peterson and his attorneys are currently challenging that. They want that charge thrown out based on the Second Amendment. They argue that the NFA restrictions on suppressors is a violation of the Second Amendment. The district court in that Peterson case denied the motion, finding that silencers are not bearable arms, that they're simply accoutrements and not protected by the Second Amendment. That decision currently, was also upheld by the Fifth Circuit 3-judge panel, but currently it is elevated to the en banc panel. And right now the DOJ and the AG's office and the new task force are trying to decide what they want to do in that case going forward. But currently the state of Illinois is trying to use that Peterson decision, and they argue that Peterson holds that suppressors do not trigger Second Amendment protection, thus rejecting the same theory pressed by the plaintiffs in these consolidated actions. As the Fifth Circuit explains, whether a suppressor constitutes arms is an issue of first impression in our circuit. Insofar as we can tell, every court to have addressed it has decided the question in the negative. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of firearms accessories is not. As the government aptly explains, an operable firearm will work perfectly well without a suppressor, but a suppressor will not transform an inoperable firearm into an operable one. Moreover, it can hardly be said that suppressor regulations have rendered the right to bear arms meaningless. That decision by the Fifth Circuit is likely going to be reheard and challenged at the Fifth Circuit en banc panel level, and right now the AG's office, like I mentioned, is trying to decide what they want to do, and they're having the new 2A task force look at that case. Now, going back to this Illinois suppressor case, this week the court heard arguments on this motion for judgment on the pleadings, and it's going to decide if this case is going to be thrown out early or will it be allowed to proceed forward. And it sounds like the hearing did not go well for the state of Illinois. Coming from Stephen Stambuli, Stambo, who is an amazing attorney. He is the plaintiff's attorney here. He works for GOA and files a lot of 2A lawsuits. He's an amazing guy, friend of the channel, but even greater, 2A attorney. He does amazing things. He stated after the oral arguments that we had a little over an hour and a half argument today. Judge wasn't buying that suppressors aren't arms. Lots of procedural questions on the motion Illinois filed. The judge didn't seem too happy with some of the answers he was given by Illinois. No timeline for an opinion. So again, shout out to Stambo and the great things that he does for the 2A cause and all these lawsuits that he files. So it sounds like the arguments went well for the pro 2A side, and that the judge is potentially leaning towards denying this state motion. That means that the judge will likely reject this absurd argument that suppressors are not arms and therefore are not afforded 2A protections, and this lawsuit will be allowed to proceed forward. Now, I will echo some of the things that Stambo had said in regards to this case. One of the things that I would love to see is for the AG's office and the new 2A task force to step in and file a statement of interest in this case, maybe file an amicus brief in support of this case, and support the plaintiffs here in their challenge against the state suppressor ban. It would be nice to see the Trump administration step in and argue against these type of NFA bans. We know that they are very much aware of the Peterson case that's going on, and they're taking an active look at that case, but it would be nice to also see them transition to some of these state challenges. We know that the task force and some of the actions by the AG's office have looked at some of these state actions which violate the 2A, rights of individuals. They've looked at some of the CCW restrictions in counties like Los Angeles, and they're taking actions against that. It would be nice to see them take actions also against these type of state NFA bans. So this is something that we're going to be watching closely, and I'm very interested to see how the judge rules in this case. It would be nice to see him, reject these absurd arguments that suppressors are not arms and not protected by the Second Amendment, but we will have to wait to see how this plays out. As we get more information, I'll let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.